Welcome to A State of Mind, Law, Legacy, and Life with Sunny.
Hello, everyone. Welcome back to A State of Mind, Law, Legacy, and Life with Sunny, Principal Attorney at Rickard Law, APC. Sunny works with families across California to create thoughtful estate plans that protect both their assets and their ability to make decisions with confidence. I'm Sean O'Connor, and today we're focusing on what happens if you're still alive, but maybe you become incapacitated and unable to make decisions for yourself, and how to navigate that. Sunny, how are you? Good to see you.
Good to see you, Sean. How are you doing?
I'm doing great. This is super important information today. I'm wondering, when people think about estate planning, they often focus on, what happens after they're gone, after death. Why is incapacity planning just as important?
Yes, Sean, it's such an important place to start. As you said, most people come to me thinking about estate planning is all about that what happened when they die, their will and who gets their house, etc. But statistically, we are far more likely to face period of serious incapacity during our lifetime than you just die suddenly without any warning. Think about a stroke. Think about a car accident, a progressive illness, or many people getting old, they get Alzheimer's disease or dementia. And as we're aging, and we can see those scenarios, those conditions happen more often. So if something like that happened without the proper documents in place, your loved ones cannot legally manage your bank accounts, help you to pay the bills, or make those healthcare decisions for you. Even if you're married, many people probably didn't realize that even married couple, when dealing with the situations, not necessarily just because you're married, you automatically can have the capacity to help your spouse. So the court usually get involved in this kind of situation. And that process is called the conservatorship process. That process can be expensive, slow, and emotionally kind of exhausting for the families that already kind of under the pressure.
Yeah, I'll bet. And I know that, I don't know, but I'm pretty sure that, some of these laws vary from state to state. And, for our listeners, you're based in California, and I'm curious, what is a durable power of attorney in California, and what authority does it give to the person you choose? I assume you're choosing to give someone a durable power of attorney. Give us some background or better understanding of that.
Well, in California, we actually have the form called statutory power attorney. It's kind of a standard form. Many people can use it. Or you can draft your own power attorney. Both kind of documents will be valid in California. A durable power attorney is just legal documents. The principal, which is you or the people that wants to sign this document, authorize another person, call your agent or the attorney in fact, to manage the financial and the legal matters on your behalf. So the term we call the durable is pretty critical. It means that the authority survives your capacity. Even if you incapacitated, this power attorney still going to be effective. So that's what durable really means.
That takes me right into the thought around okay, so how does a financial power of attorney differ from a healthcare directive? And I'm assuming you want both.
Yeah, a durable power attorney usually controls a pretty broad bank accounts and the financial situation. You're paying the bills, filing taxes, managing your real properties, handling the investment, even helping you running the business. But the important thing is the durable power attorney usually cannot help you to decide where you can live, or help you to manage the medical decisions, or get access to to those medical record. So most of the time in California or most states, if you are over years of 18, the doctors has obligation to keep your medical information confidential. So that means that if you're parents of a college student, your children's doctor will not talk to you once your children reach the age of 18, unless you have you call it advanced healthcare directive from your children. And also in many situations, when you aged parents get into the stage, get dementia or Alzheimer's disease, their doctors will not talk to their children either, unless you have these proper documents in place, authorize you to be your parents or your children's, we call it healthcare agent or healthcare proxy or the healthcare attorney, in fact. So that's very important to have both documents in place. One is called durable power of attorney, which helps you to manage the financial affairs dealing with the bank, taxes, and other kind of governmental agencies. The other one we call the advanced healthcare directive or healthcare proxies. Those documents can help you to navigate how to deal with the medical decisions, the living arrangement, and medical informations, those kind of affairs if you becomes incapacitated. The one thing that people need to understand is if you have the capacity, the doctors, the hospitals will not listen to anybody else. Usually the doctors and nurses and hospitals will ask you, what do you want to do? Most of the time is when you lost that capacity, those documents becomes very important because you have to authorize somebody that you trust and authorize the person the scope of the decisions he or she can help you to make on your behalf. And in California, actually, the Advanced Healthcare Directive include two parts. The first part is you authorize who to be your agent to help you make those decisions we are not able to. The second part is really about the end of life decisions. In what kind of situations you do not want to continue the treatment. So the California's Advanced Healthcare Power Attorney can include the healthcare agent designation and also include the living will on the end of life decisions.
Let's briefly walk through maybe a worst case scenario, right? Where someone becomes incapacitated but doesn't have these documents in place. What are sort of from a top level, what are the ramifications of that, Sunny?
It can be devastating. In California, if you don't have a power attorney or a healthcare directive and you become incapacitated, your family cannot simply just step in. Even the spouse cannot access the the other spouse's bank account and some of the financial institutions account, like your retirements, like the 401ks. If you don't have proper power attorney in place, even you're the spouse of the incapacitated person, you still cannot get access to that. So the only way you can get access to it is go to the court to petition for the conservatorship. So the conservatorship is kind of the legal proceeding that you becomes the conservator or the guardian of that person. So the conservatorship in California has two kinds. One is conservatorship of the person. The other kind is conservatorship of the state. The first one, conservatorship of the person, is give you the power to decide the medical decisions and the living arrangement. And the conservatorship of the state allows you to help the incapacitated person to manage their financial affairs. This process can take months to complete, even though that in some situation you can go to the court to ask for the temporary conservatorship in the emergency, the urgent situation. For example, if the house is flooded and needs somebody to step in immediately, or this person needs somebody to has mental illness and needs somebody to pay attention to care for him or her immediately, you can go to court to ask for the temporary conservatorship. Those hearings usually can schedule a little faster than the just general, we call it probate conservatorship. But in any event, that can be a prolonged and costly process.
Yeah.
And I can give you example that one of my clients, the husband got a stroke, and the husband has the retirement account and have a mortgage need to pay, and they own the real estate, and the husband also have a child from the previous marriage, and because husband doesn't have any proper documents in place, there's a dispute between the family members who should be controlling his finances. So this becomes a heated kind of matter, has to be disputed and fight in the court. So that's the one of the examples I can give my clients that if you don't have proper documents in place, this can be devastating to your family members.
Yeah, especially during, what's already a stressful time. Now, what about the flip side of that? I know you've worked with a lot of families over the years. What about a situation where having the proper documents in place made a big difference for the family? Anything? I mean, I suppose just having them in place probably makes a big difference for every family, but anything in particular, any particular story that you want to share?
I have a similar situation. There's a couple I helped with in their 60s, and they're still working, very healthy when they came to me. So they have the very comprehensive, we call it responsible planning, and they very detailed listed in their power of attorney and medical advanced healthcare directive, what kind of situation they want the treatment, what kind of situation they do not want the treatment, and what kind of treatment, what kind of situation they absolutely do not want. So this is, and unfortunately, the husband 3 years later has a stroke and lost ability to speak. Because all these documents in place, that the wife is easily to get access to the husband's retirement account and withdraw that amount, the retirement payment on behalf of the husband. So that can ensure their life still goes on smoothly. It's not going to be interrupted because the wife cannot get access to her spouse's retirement account anymore, and it could be that income resource can be cut off. And also the husband needs to be sent to a nursing home because it's just too overwhelming for the wife to still keep the husband in their house to provide 24 hours care. So that process also went very smoothly. The wife can act on behalf of the husband to talk to the nursing home, to talk to doctors, to talk to nurses, and to set up what kind of care standard that she or her husband actually wanted for the husband's care. So this is a very good example that proper designed and prepared documents can really help you through those difficult times.
What do you recommend to potential clients or your clients when they're selecting an agent under a power of attorney or a healthcare directive? What qualities should families carefully consider? I mean, obviously, if it's a husband and wife situation, that probably is the obvious answer. But what's your advice on that?
Yeah, this is one of the most important conversations I have with every client. People always like to default to the oldest child or family members who lives close by. And of course, most time probably you default to your spouse because the spouse probably is the person that understands you the most and you're closest. But I think it's not necessarily always choose the people always live close by or their oldest child. I think there is three things has to be considered. One is trustworthiness, their availability, and the capability. So, if this person is when you appoint one person, you have to understand that they have a lot of power. They can act on your behalf. So of course you have to trust them to make that decisions for you. And they have to reasonably understand the finances. They understand how to deal with the money, how to do the investment, and they have to reasonably understand our healthcare systems. And this certainly is the availability. If it's this child, him or herself have a large family and have worked constantly, work all the time, travel all the time, even though that he's a very capable person, he might not be always available. So I think these three criteria are very important to consider who are the agent. And on top of that, I think you have to consider if this person is a caring person, right? They really cares about you. They really care your well-being. I think those factors all should be considered. And some families maybe not have those people available, and they can also consider, we call them professional fiduciaries, and they are actually the people are designated to help those people that's really have anybody available to them. Of course, they are paid services, but sometimes they're probably better than you just randomly select some people that make those important decisions for you.
Got it. That's great. Well, listen, we are we're going to continue this conversation, I'm sure, in a future episode, but for now, we're out of time. Sunny, great talking to you.
Thank you, Sean. And I think, yeah, as you said, these are very important topics, and it's really can affect your life greatly in those kind of unfortunate situations.
Well, that's it for today's episode of A State of Mind, Law, Legacy, and Life with Sunny. To learn more about creating a complete estate plan that protects you during life as well as after, visit cyrlaws.com. And if this conversation was helpful, or if you've got someone in your life that would benefit from it, share the episode, subscribe to it, and leave a review. Thanks very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.